Hey everybody, back with you tonight. Elizabeth Nader with Jersey First TV. Tonight's episode is incredibly important. I want to welcome lawyer John Coyle. John, welcome to Jersey First TV.
Thank you, Elizabeth. It's wonderful to spend my Thursdays on this side of the computer with you as opposed to normally just watching you and everybody else. I'm very proud to be here.
Well, thank you, John. I respect you immensely. Tonight's topic is so important, as I have said. We are going to cover as best we can in a 30-minute format, which is not going to be easy. COVID and the workplace, COVID and schools, COVID and mandates, as many things as we can help people understand. You know, John, we've been inundated with questions at Jersey First about what are my rights? What can my employer do? What can my school do? A lot of questions swirling out there. And before we get started, I want to just, make a few disclaimers to the audience. You know, John is an incredibly successful attorney, he has his own law group in Morristown. He is now fighting these cases. He's been fighting for people's rights for a while, but it's an emerging area, right, John? I mean, we don't know a lot of things yet. Precedence is when things are litigated, and then therefore we start to see how the courts are looking at issues. So the first thing I want to say to everybody is we will do our best. John will do his best to give you what he does know today. This show is not an opinion about getting a vaccine, not getting a vaccine, wearing a mask, not wearing a mask. That's not the point of tonight's show. Tonight's show is about informing you as best we can as to where things stand legally in this state and in this country, and what you can expect as far as we know in the future with some of these open issues. So John, did I frame that okay?
You did perfectly. There's a lot that's known and not done. I'll do my best to let you know and your viewers what I'm saying when I'm trying to extrapolate or what I'm trying to project from the law. But you're correct. This is an ever-changing field of law, and what's the case today may not be the case tomorrow.
Right.
But I can do my best, because the truth is people need to hear the overall answer. Doesn't matter what your position is on masks or vaccination or any of these things. Right. You need to know where to start, because there's too much misinformation that's out there.
Right. And that's a good place for us to start. We want to start with some myth busting, because there are a lot of things that you hear, and we all, I guess, are playing lawyers here, trying to figure out what are our rights? How does this fit into the Constitution? What does this mean? So sort of off the top of your head, John, and if you forget any, I'll remind you, what are some myths that you would like to sort of bust or sort of set people straight on that you've been hearing?
I think we could do this for another couple of videos and not cover everything. I think the real important thing that everyone needs to look at when they frame this question about any of these aspects of anything we're going on now is there's three parts to it. The first is this permitted? The second is, what are the rules or requirements for opting out, opting in, and conditions for it? And then the third is, if you get that, then what happens next? And that leads to framework of all these myths that people look about these. And the first one is whether or not requiring vaccination or masking is permitted. That's the first step. Is this something that's permitted under the law? And I will tell you that under the current government guidance for the EUA approval of these COVID vaccines, and there's a disclaimer there. The disclaimer is that there's a lot of people challenging these things, but I'm telling you what the official government's position is that these vaccination requirements are permitted in the workplace. Okay. And that's step one. That is clear law under the EEOC, which is the Equal Employment Opportunity Commission's interpretation of the implementation of these laws, right? And the EEOC is the federal agency, a part of the Department of Justice, that is tasked with implementing workplace discrimination. Right. Whether it's ADA for medical discrimination, Americans with Disability Act, the Civil Rights Act for example, religious discrimination, or GINA for the Genetic Information Non-Disclosure Act. Okay. The EEOC is the federal point person for that. And as it stands today, the EEOC's guidance is these are permitted in the workplace. Okay. But again, that's not the end of the discussion. And I know that there's a lot of people talking about EUA, emergency use authorization. These have not been given full approval. Right now, the Department of Justice has said the EUA law allows these vaccines to be mandated. Okay. And I will tell you that there's a reading of the Food and Drug and Cosmetic Act that supports that. I've also seen people give an alternate reading that challenges it. And the purpose of this is not to tell you my opinion for what I think is right or wrong, but right now the established law is that these are permitted. That's
So,
step
so I think that's an important myth buster, if you will, that the emergency use authorization is kind of a non-issue right now that may be litigated, may not. Of course, we're going to probably going to see full authorization by the FDA on some of these, but regardless, you're saying it's really not a path that we can go down right now. Some people may be trying that, but as we see at face value, the status of the vaccine as an emergency use authorization does not affect the permission or the ability that the employers have to mandate it.
That's 100% correct. And in fact, some of the few court decisions that we have had around the country have affirmed that.
Okay. All right. All right. So that's one. Let's talk about masks. Why are masks allowed to be mandated either in the public square or in a private business?
This comes back down to a general question of push and pull in the law. Where's the government's boundaries with respect to public health emergencies? And the laws have historically been written in such a way or interpreted in such a way to give the government broad latitude for interpreting what to do in a public health emergency. And in some of the cases that went to the Supreme Court in 2020 during the first round of COVID, so to speak, you saw the courts taking a very hands-off approach. And it's for a reason. The states and federal government are set up with health departments, the State Department of Health, the FDA, the CDC, and the courts say, quite frankly, a judge sitting somewhere, whether it's in Supreme Court in Washington, D.C. or in Trenton or anywhere else, is not in the best position to be on the front lines in terms of evaluating this. That, quite frankly, every aspect of this that we're going to talk about, there's competing science on both sides.
Right.
There are a long list of people who say you must do this, and there's a long list of people who say you can't do this.
Right.
And the judges are like, I'm not weighing this.
Okay.
That's
so
unfortunate.
They're default, which is why we're seeing the difference in all the states. They're defaulting really to the Department of Health in the states to a large degree. And the other question people have, it maybe is a myth buster question, is a mask not a medical device? And is it or is it not? And we see on the box of a mask that it says it's not intended to be used to stop the transmission of COVID. So how does that play in?
So the mask in and of itself is not a medical device as authorized by the Food and Drug Cosmetic Act. The question gets a little trickier when you talk about how it's applied, right? Mm-hmm. Pre-COVID, you could have gone to Home Depot and bought these exact same masks. Right. You could have bought these. I mean, KN95s were at the paint store for people using paint fumes. Right. They weren't medical devices in that sense. They obviously had a medical component or a medical aspect of this, but these weren't medical devices. And the same thing with the typical paper mask that people commonly wear, or even these cloth masks. Right. It gets a little closer to the line when people talk about it's being ordered for this particular use. Could that make it a medical device? And the answer is maybe, but But backing up to this, there is a difference between something that is approved as a medical device as under the emergency use, whether it's a vaccine. And by the way, this predates COVID. Right. On the emergency use authorization list, there still are vaccines or shots for things that are from years and years ago that just have never gotten the final set of approval.
Right. Okay.
But these respirators are also like the intubations are also part of the emergency medical devices.
Okay. All right. So the myth we're busting there is that it's not really seen as a medical device at this point. Therefore, an argument that I'm being forced to wear a medical device and I need informed consent. And that whole trail that we can go down really doesn't apply, and at this point hasn't been a legal avenue to take. Now, having said that, informed consent is a big deal to a lot of people. I want you to look at it two ways. Yep. One, and I've had this direct question: how does a Nuremberg Code fit into this? Which, of course, we know is about the necessity to protect people from being subject to experiments, being subject to medical interventions that they don't want, that people need to voluntarily consent. So how does that play into this at all?
Right. The idea of medical consent is a foundational value in our entire culture and Western medicine and every aspect of life that we have. I'd like people to, if they could take one thing from this, is to actually take the word Nuremberg Code out of their vocabulary.
Okay.
And I say this for the following reason. It is a phrase that was not primarily used for the best part of 50 or 60 years, and for a good reason. At the end of World War II, the Allies held a number of trials of Nazi war criminals in Nuremberg in Germany.
Right.
And out of those, there was a trial that was referred to as the doctor's trial, technically called USA versus Baker. 24 different defendants who were accused of conducting medical experiments in the concentration camps. And some of them weren't actually really treatment. Some of them were just really, you don't need me to go into tell exactly what was going on.
Right.
And in the course of that trial, which took quite a long time as these things played out, it became a question as to whether or not these doctors could say, I was just doing medicine. Okay. And the defense lawyers were raising this. These are just benefiting society by doing medicine.
Okay.
And in response to that possible defense, the prosecution team, which was doctors and lawyers and everybody else, came up with a list of guidelines where they said, these are the rules we'd like it to be for determining whether or not medical action is voluntary.
Right. Okay.
And they came up with a list of 9 of them.
Yeah.
And at the time of the trial, the judges said, I'm going to expand that to be 12. When people look at the Nuremberg Code, they're referring to that list of 12 things.
Okay.
I'm going to put one disclaimer on this, and this is the reason why everyone's nodding along and saying I'm familiar with this and everything else. None of those defendants were charged with violating this. None of them were charged with violating the Nuremberg Code. These 12 things that the judge came up with, none of them were charged with it. None of them were convicted of it. None of the aspects. As a matter of fact, of the 24 defendants, a number of them were acquitted of things.
Yeah.
And the ones that were convicted of crimes against humanity.
Okay.
The point is, since then, no country has ever adopted the Nuremberg Code, those 12 things or any permutation of that, as anything under any stretch of the war as law.
Oh, interesting. So there really is no precedence. There really are no cases to point to, and this is in itself a concept that hasn't been applied. Well, okay, that's interesting. So we're going to stop saying that, but let's then translate to what informed consent is, because there's a relationship in terms of the concept. So what really is informed consent, and how does it apply to the mandates that we're seeing, to potentially a vaccine mandate? How is that either a protection against that, or just basically not a tool that can be used?
I will tell you, informed consent in the law, at least as it applies to vaccines under the emergency use authorization, requires a patient who's going to get the vaccine to be shown the fact sheet for the vaccine. There's on the Food and Drug FDA website, there is a fact sheet that you can click on for each of these vaccines, and showing you that fact sheet is considered informed consent.
That's all it is. All I have to do is be handed that sheet. And if there is a vaccine mandate, which we'll talk about a little bit later, it's enough to meet that requirement that the doctor or the medical professional, in this case, whatever, has handed me that document, and that is considered informed consent. But John, if I'm not consenting, how does that fit the definition?
I chose my words carefully. It's the legal definition of informed consent under the EUA. Okay. And as we sit here as people who, regardless of your political affiliation, have the concept of rights and how you look at these things, that doesn't feel like informed consent.
Right.
As an analogy, I cut my hand and went to the hospital, and I'm sitting there and I have my hand cut open. I cut some tendons in my hand, and they hand me a thing that's got 4 pages front and back full of information, asked me to sign it on the bottom before they do surgery. And that's informed consent.
Yeah. You're signing, and you're probably not reading it, but that's enough to meet that requirement. Okay. So we're going to get back to that a little bit with mandates. I want you to touch on something else, which is legal precedents. Yep. A lot of these things now, it seems to people that it's going to have to be litigated. There's so much confusion over what is okay, what is not. We are starting to see some of this happen. There is a case, though, from the early 1900s regarding smallpox. Can you just quickly weigh in on whether or not that is a legal precedent that points to the right to mandate a vaccine universally?
Sure. That's the Jacobson decision. That's the one that everyone's talking about, as the Supreme Court authorizing the right for vaccines, right? So I'm going to give you the lawyer answer, which is the following. It's precedent. And precedent simply means that a higher court has issued this. And in the court's hierarchy structure in this country, from traffic court, municipal court, state court, federal courts, the Supreme Court's at the top. So at the top of something, the Supreme Court's decision on something is binding precedentially on the lower courts below it, in the same way in which New Jersey's Supreme Court is binding on the appellate division, which is binding on the trial courts, et cetera, et cetera. So Jacobson is binding precedent, has not been reversed. Now, the tricky thing to remember is the entire job of a lawyer, don't mean to minimize what we do here, is comparing and contrasting. Okay. Everything is, we have a system we call a common law system, right? There are some states or some countries, for example, France is a statutory system. There's the law, it's in the statute, a court applies a statute. The court doesn't go beyond it. And as a matter of fact, their system has done that. When a court case comes up on something, the legislature goes and amends the law, like in the middle of this. This is just their system. We descend from the English common law. Common law means judge-made decisions. We look to statutes, but we also look to precedent, okay? And every time you look to precedent, there's something that says this and something that says this. And on some level of specificity, everything is the same, and some level, everything's different.
Okay.
In the Jacobson decision, it required regarding smallpox requirements.
Right.
Violating them involved a $5 fine. And Mr. Jacobson had asserted a religious objection to this, and that was overturned by the court, or the court said basically, in looking at things in a public health emergency, we're allowed to require this, sorry, notwithstanding your religious beliefs.
Okay.
That decision has been used since then for an awful lot of basis. And on some level of specificity, you could say, well, that case supports the government allowing in a public health emergency to mandate treatment for smallpox or for another disease over a religious objection.
Right.
Which it does.
It would appear that way. Right.
It also could be said that the question of what somebody's rights are, if there was a requirement that says, I need you to get the COVID vaccine to go to college, and if you don't, you have to pay a $10 fine. The question of how the court's going to look at those rights and how it's implicated. I didn't move enough and my light turned off.
Okay, hold on. We'll get that back on. This is live, so this is what happens. I love it. Okay.
Okay, great. I need to be more animated. That's normally not a problem I have.
Yeah. Or not have so much technology in your office.
Sure. But yes. So the question of whether or not Jacobson is still controlling is an interesting question. And it comes down to whether or not you look at this and say, this is the same or this is different.
Right.
I will say, and I don't want to go down a law rabbit hole here.
Right.
Jacobson has been used over the years to defend and as the basis for a lot of things that we would consider morally repugnant to this point.
Okay.
There's a famous, of course, case about the forced sterilization of people that society has deemed unfit.
Right.
Regenerations of imbeciles is too much. And they cited as that C. Jacobson as the defense for this. Okay. And in and of itself, that case from the Supreme Court has not been overturned. Okay. The law has been overturned that allowed people to be sterilized. But
that case is still there, but precedence is not a guarantee. Like you said, you have to take into account, right? If you use that or you argue against it and what is different. But it brings up another point, which we need to discuss, which are exemptions. We have in New Jersey, religious exemption and medical exemption. Do those apply only to school-age children, or are those available to adults as well as, for now, as long as the law stands, as valid exemptions to any mandated vaccine?
So that's a great question. That's probably the central question we're really dealing with right now and everything going on. And so we got the first question we talked about earlier. Can your employer require you to get the vaccine as a condition for work? And the answer is yes. The question is, can you object to this? And as an adult person in the United States, and I'm choosing the United States, not even New Jersey, you have a First Amendment right to the free exercise of religion. Okay? And the EEOC, the Equal Employment Opportunity Commission, has held that the Civil Rights Act, the 1964 landmark legislation that took on discrimination and has evolved over the years from racial discrimination to religious discrimination to gender, ethnicity, and everything else along the way, and sexual identity, protects religious rights. Okay. And the EEOC is crystal clear, pre-COVID and post-COVID, employees sincerely held religious objection to mandatory vaccination is protected under the Civil Rights Act. If you have a medical objection to vaccination, medical not objection. But if there's a medical reason that you shouldn't be doing this, the Americans with Disability Act would cover you under that, and you'd all go through the EEOC.
Okay.
I chose my words because they're intentional, sincerely held,
Right.
religious objection.
Right. Right. But having said that, there is no test for religious tenets. Has the Supreme Court weighed in on that? In other words, how would one go about proving, or would someone try to disprove your religious beliefs as a tool for you to have that exemption? Where does that get argued?
Yeah, and this is where I'm seeing the biggest confusion and the biggest possible abuses. And I won't say abuses judgmentally, deviations from the law. And I think a lot of this is from employers who are looking for honest answers to what they should do and what their tests are, and employees who are trying to figure out where are the boundaries of what they can do. The Supreme Court has weighed in on this a number of times, mostly in the context of not vaccination, because there aren't a lot of vaccine cases in the law.
Right.
But there are a lot of cases talking about religious objections to everything from prison practices to specific things. There's ones that come up where somebody works and they change their religion, and now they need to ask for a Saturday off or a Sunday off to accomplish their religious belief. And their employer says, no, you're fired.
Right.
All these things come up in different ways. And I will tell you the Supreme Court's test is it doesn't matter if your belief is the subject of something you could name, Catholicism, Judaism,
right.
Islam. Doesn't matter if it's one of those things. It doesn't matter if you are a participant in one of those religions or an adherent to those religions. If that religion says this is not one of our beliefs,
right?
That doesn't matter either.
Doesn't matter, right.
What matters is this a religious belief in nature? And what that means is, does it deal with the ultimate issues of life, death, where are we here, why are things like this? If it is dealing with things of a greater metaphysical sense in you, it's considered religious.
Okay.
And then if the question is your sincerity of it, not even whether the religion is part of this.
So that's an interesting piece of it, which we won't go down that rabbit hole too much, but sincerity might look at things like, how long have you claimed that? Have you previously vaccinated, but this is a vaccine you don't want? And for those wondering, other states have a philosophical exemption, which is a simple one to say, I don't want it, which allows you to cherry pick. So we're not going to go down that rabbit hole right now. That's another show for us to do, but religious exemptions still stand in New Jersey. Of course, there is I don't want to use the word consequence, because let me use the word you've used, accommodation. Yep. So if in my job, I claim a religious exemption or even a medical exemption to a mandated vaccine, that is acceptable unless, assuming the employer doesn't challenge it based on what we just discussed. However, they have to then give me proper accommodation. What that really means, John, is what? They could make me move my office, stay at home, wear a mask. What is an accommodation?
The answer is any of those things, right? And the word intentionally is reasonable accommodation. And that's a term of art under the EEOC, whether it's dealing with disability or exemptions or any of those things. Reasonable accommodation doesn't mean I now say I don't want the vaccine, and the employer goes, okay, I accept this. And just one thing I didn't say earlier, the EEOC standard is an employer is supposed to accept an employee's assertion of religious belief unless they have an objective reason to question it.
Right.
And you mentioned some. There's an infinite list of objective reasons for it.
Yeah.
But the question of what's a reasonable accommodation is going to be the thing that I'm going to be able to give you the least specifics on.
Right.
Because what's reasonable today might be excessive tomorrow, might not be enough tomorrow.
Right.
And it might depend on your job, who you work with. What the EEOC participates in what they call the interactive process. That's working with an employer and an employee to talk about this. It's easy to understand the pre-COVID context. Right. If you wind up confined to a wheelchair for some purpose and your job is on the second floor of a building that doesn't have an elevator, and you say, I have now a disability under the Americans with Disability Act, I'd like you to move to build an elevator for me.
Right.
And one of the factors the EEOC considers is the impact on your employer.
Yeah.
And in that case, I'm going to tell you, they're not likely going to be able to make them build an elevator.
Right. Right.
They might say, we can move your office to the first floor, but what if that's not the nature of it? Maybe we can modify your time in some way. Reasonable means so many different things,
Well,
right?
and it means, and the way you're describing it is, on the one hand, what someone is asking of an employer, and really what we're talking about ultimately will be what the employer asks of you. So let's
Yes.
stick with employers for a little bit longer here. A couple more questions for you. HIPAA. Now,
Mhm.
people have been claiming HIPAA, meaning that your medical records are private. And so now we've got this question where employers and restaurants and others, and we'll get to that in a minute, but let's stick with employers, are asking, have you been vaccinated? And they want to know this. And is that legal for them to ask that question? How does HIPAA apply, or does it in the workplace?
Right. HIPAA is one of the most misunderstood laws that we have. It's one of the most important, but also one of the misunderstood. HIPAA applies to your medical professionals and to people who handle medical records for you. So HIPAA means your doctor can't, if somebody calls up and says, "Hey, how's what's up with John?" Your doctor can't disclose that.
Okay.
Okay. HIPAA applies to your medical professionals, period. It extends to people who otherwise see those records. For example, your insurance company. They get your medical statements or things along those lines. HIPAA binds them, and your employer, if certain things come up through them, HIPAA binds them. HIPAA doesn't bind the world from not knowing your information. It doesn't, you don't have a HIPAA right. Hey, you can't ask me my condition. That's
Right.
a HIPAA violation.
Right.
No, no, you
Wow.
can't ask my doctor is a HIPAA
Misunderstood.
violation.
That
You
we
can
should
ask me.
we should have started with that myth, because I mean, I know you hear that a lot, and so do I. So it's a narrow application. It is not universal. So let me ask an obvious question then. If my employer mandates a vaccine and I choose not to get it, is it okay? And I don't know yet if this hasn't been litigated yet, but is it legal for that employer to make me wear a yellow lanyard indicating, or even continue to mask when others are not, which is another symbol, indicating that I am not vaccinated? Is that legal, or is that a civil rights infraction?
It could be both. And that's the question. It comes down to intent. And I will tell you that the pre-COVID standard for this is a lot more defined. Okay. In the pre-COVID era, there were requirements for medical workers in New Jersey to get the flu vaccine.
Right.
And despite what a lot of people said, that you still had a religious exemption under it, as we discussed before. And when you had a religious exemption of it, and nurses or medical professionals had it, they were required to do certain things. Sometimes they were required to put a little blue dot on their badge that says they haven't been
Right.
vaccinated for the flu. They may have been asked to wear a mask during the time. In the interactive process in 2019 with another nurse that I was participating in for this, the question was, she offered to say, "I'll wear a mask during flu season." And the employer laughed and said, "That's ridiculous. Nobody would wear a mask for months at a time in a hospital."
Oh my gosh, can we get that quote? That's amazing. Okay, so that's changed.
So reasonable means something totally different all the time.
But you can see, though, the
Of
concern.
course.
You can see, I guess, the obvious question. And again, I want to say to everybody, this is a question people have, whether they are wanting to get the shot or not get it. We want everyone to make that choice as they see fit for themselves and their family. But the obvious question is this segregation? And let's pivot a little bit to the
Right.
restaurants, because this is
Yeah.
coming out in any private business who is saying, you're allowed in, you're not allowed in, show me your papers. Now, there's a lot of emotion behind these statements. What are the legal arguments for or against those kind of positions?
Right. So the current status of the law in New Jersey is places are allowed to voluntarily require masks, and they're required to do these things. Whether they're allowed to require vaccine status is really up in the air. And I will say this, that I've heard people say it's absolutely permitted, and I don't see them point to anything. And it seems repugnant to my concept of rights, regardless of your position on vaccination. But in a public health emergency, there's a lot of emergency orders flying back and forth and back and forth. And there might be something being filed right now that would change all this. I will tell you that in some states, for example, New York has passed broad laws about requiring vaccination proof to enter certain venues. I'm sure those are going to be challenged.
Right.
Uh,
Right.
the discrimination question is a really tricky one, and I could speak to about how a recent court decision from Indiana
Yes, thank you.
challenging this talks about this, right?
Yes.
And the question is, so in New Jersey, since I know we're Jersey first, some of the colleges have handled this differently. Some of the colleges have said if you're not vaccinated, you're not allowed in the dorms. And there's another college that said if you're not vaccinated and you give an exemption, there's a non-vaccinated dorm.
Right.
And is one discrimination and is another discrimination. And they both are, and they both aren't. And it comes down to, is it better to say no one's allowed in the dorms, or is it better to say you all have to be in these dorms? And I don't know the right answer. I sort of, in some sense, feel sorry for these colleges who are trying to figure out how to do this, because I was outraged that they weren't allowed to be on campus. And then I was more outraged that they had to be allowed to be on campus, but in a segregated building.
Right.
And I don't know which is actually more violative.
Right. So what did the Supreme Court decide with Indiana? Tell us.
Well, actually, before the Supreme Court, I'll promise not to go long. One of the questions, and it was a challenge to Indiana University's policies about this. And one of the things that was raised was that this is discriminatory, making unvaccinated kids wear the mask.
Right.
And the judge on the district court said it's not, because a lot of people are going to be wearing masks for different reasons. There's people who are not going to be wearing masks for religious objection. There's people going to be wearing masks for medical exemption. There's people going to be wearing masks because they're afraid of COVID. The fact that you're wearing a mask is not a stigmata of discrimination. Okay? It's an interesting take on it, but that's how this worked up. And it went to the Court of Appeals and up to the Supreme Court that this week denied it. Denied the appeal. Now, I need to be clear, and this is where we get in the legal question. This was a request for an injunction.
Yeah.
Right? And what that means is when you're asking for a court to interrupt something, people are asking for, you have to stop this policy, you have to do this, everything else. When you're seeking a court order to stop somebody from doing something, an injunction, you bear a much higher burden than you do with just winning.
Sure.
Right? And the court in that Indiana case said you don't meet the standard for an injunction.
Which is different than the court hearing it and making a legal decision. So once again, we're a little bit in no man's land because these cases have not been fully litigated. So we don't know yet where the court is going to land on all of that. I think another question that people would have is that if you work for a public entity, if you work for the state, do they have more rights or less rights than a private company to mandate shots, testing, masks?
They have the same rights. And I say this in the terms of no matter what the state of New Jersey is going to pass for rules, regulations, and laws, the Civil Rights Act trumps anything the state of New Jersey does.
Right.
New Jersey can't violate the Civil Rights Act. They can't violate the federal constitutional rights. They can't violate all these things. So as it stands right now, and I chose the words at the beginning intentionally, any employee in the United States is governed by the Civil Rights Act, the Americans with Disability Act, GINA, and goes through the EEOC. There's public, private, state-owned, New Jersey, Alaska, wherever you are, it's the same standard.
Okay. Now let me ask you about testing, because this is another one I think that we're not sure where that's going to go. We're starting to see some schools say, if you are unvaccinated, you have, and maybe you get contact traced, you have to test before you come back. We're also seeing some businesses or some other entities saying, well, okay, fine. If you don't want the vaccine, then we're going to raise the standard of testing, let's say twice a week, let's say on your own dime. That whole area of how often can you mandate testing? How often do you have to test? Is it on your own, financial wherewithal to do so? All of that category, have we seen any litigation with that yet?
Yes, but nothing that's hit a point that I think we have a decision on it.
Okay.
Right? On a global level, on a workplace, this is still a question of accommodation. I had a client I was working with who did remote telehealth therapy, right? Pre-COVID and during COVID. And her employer said, you need to test twice a week because you're not vaccinated. And the question came, but she works at home through her computer. And we argued that that's not reasonable.
Right.
And her employer said, okay, you got me on this. You back up.
Okay.
There are people who say, I've opposed the nasal swab for various reasons. We don't need to literate all of them. There are some people who have a religious objection to the nasal swab because there are certain bases for that. And that becomes an accommodation question.
Right.
Right now, the time, place, and manner of the testing and who pays for it is subject to those same words. You're going to hate hearing me say, which is reasonable accommodation.
No, I think that's helpful, John, because as people try to navigate this landscape and understand what their rights are and are not, it's not so easy. But if you use those standards to say, okay, that seems unreasonable to me, then that would be if I came to you to help have your legal assistance, we would be having that conversation. Why do you think it's unreasonable, and do we think there's a good argument? So I think it's fair that you keep coming back to that because it helps people frame rather than have this sort of emotional response to what's going on. But I have to tell you, though, there is a lot of emotion. You know that.
Yeah.
There's a lot of fear. And no matter your choices, there is this sense that freedom is sort of on the line, at least freedom in the way that we understood it, or our rights in the way that we perhaps either took for granted or simply presumed were a certain way. I want to ask you this, and we have to close, so we're going to have to do this again, John. Also, because literally in a few weeks, things will change. We will see some vaccines get approved for full use. We'll start to see some more decisions come down. So we're going to have to do this again. But I want to ask you, for those that are listening who are confused and scared and not really understanding their rights, do you see any wins on the horizon as it relates to protecting the rights of individuals to make these choices and not creating a secondary society for them, a second-class citizen standing? Are there some wins that you can point to?
There are. I think there are a lot more small scale wins that people don't even realize. Across the country and across the state, there are person after person who are saying this policy violates my rights, whether it's medical or whether it's religious. And those are being fought. They're not being fought in the newspapers, they're not being fought in the headlines. And employers are, in a large sense, I'm trying to be generalized for a reason, are respecting people's rights when properly asserted and complying with the other standards for this like that.
Right.
There are thousands of people, maybe even millions of people right now who've had those victories, and they have their jobs as a result of it. And those are victories. People are winning these victories. If the answer is there a big decision from the Supreme Court that says you can't mask this, or even a validation that says you have a 14th Amendment right to body autonomy, that win hasn't come.
Right.
That win may not come. That win may not come soon enough. But on a person by person basis, on an institutional level, these are victories.
Yeah.
And make no mistake, there is hope for people who believe in rights, regardless of your thoughts about vaccination, regardless of what it says. If you're an American and you believe in respect rights, those are being validated every day.
That's good to hear. And, you know, it's also interesting, the kind of country we are, sort of the magic of the US is that the states are so different from each other. And we're seeing different state governments deal with things differently, which sort of makes it difficult for the federal government to, for example, mandate a vaccine passport or, you know, in some way weigh in on interstate travel and all of that. I'm sure that those things will all be, you know, discussed and all of that, but the uniqueness of the United States is just not a one size fits all. So that's going to be a legal battle too, right? So there are many things that we have to talk about. John, I want to have you back. I know there are a lot of people who have some really valid concerns and fears, and there's some people that frankly need to get into some litigation in order to see, you know, what their rights really are. Are you still taking cases? I got to imagine your phone is ringing off the hook. Can you give people an idea of what kind of cases you take and how to reach you?
Yes, I'm still taking cases because, as buried as I am, I'm mindful of the fact that anybody I turn away is somebody who may lose their jobs or may have their rights compromised.
Yeah.
Regardless of your feeling about this, and I'm not alone. There are a lot of attorneys, and a lot of us are working together and trying to help this. And it's hard because I try. And when something came up, I had an emergent hearing the other day. In the middle of it, my phone kept ringing and I couldn't answer it.
Right.
I am still trying to help, particularly if you know you don't need something tomorrow. I'm in a better position to help you than you are for there. The best way to reach me is by email. My email is jcoyle, first initial, last name, @coylelawgroup.com, all spelled together. I'll get to it. I have a staff of people working with me to try to triage my inbox.
Yes.
And my paralegal works really hard to stick a piece of paper in front of me every day that says, these are the emails you need to look at right now, because you can't even look at them.
Wow.
We're all trying our best, and there are a lot of people trying it around the state. And there's a lot of people who need help, and I'll try to help everybody I can.
Well, listen, John, we appreciate you. Your approach to all of this. You're intelligent. You're well informed, and I know you're fighting hard. You've had some difficult cases recently, and that's another show. So I don't know, John. Maybe we got to be on every week, right? But you've had some challenges, and we appreciate that. Again, Jersey First is all about fighting for families, fighting for businesses, fighting for your rights and your right to choose to do what makes sense for you and for your family. But we will start to see all of this litigated, and it'll be interesting to see some of these cases come out. John, we'll have you back. Thank you so much. I can't thank you enough for your time and for your insight.
Elizabeth, absolutely. Anytime you need me, I'm here. Thank you,
All right.
everyone.
You got it. And to my audience, guys, have a good night. We'll see you next week.